Thank you very much, Praedi. Greetings to honorable members and welcome back to our first committee meeting. We hope that you have rested well and continue to do your work as members of parliament. We are also joined by Honorable Groenewald and Honorable Mulder. Morning to the Minister, the Deputy Minister, the DG, and entire workforce of the Department of Home Affairs. Morning, I've cited Commissioner Love and the team of IEC who are present here. I think they will do a proper introduction when we request them to do so. And morning to our staff members of Parliament and all those that are serving at Home Affairs. We are today going to receive a presentation of the bill. As you know, that the Constitutional Court has given us a time frame to respond to this bill on electoral reform. The minister has been on the ground interacting with various stakeholders to interact with the matter and introduce the bill to Parliament. The bill has since been tabled in Parliament on the 10th of January 2022 and referred to the Portfolio Committee to further interact and consult so that we come back to Parliament and make a recommendation on how we must move forward with the electoral reform. We're going to interact, give an opportunity to the Minister, the DM and the team to present as the agenda as outlined, and also give an opportunity for the Minister to comment on the private members bill that was presented by Honorable Quota in our committee meeting. And then after on both the presentation and comments from members, we'll then outline a process on how we're going to engage moving forward on this bill. We hope that members, both the minister's team and honorable members, will be focused on the issues that will be raised so that we utilize this opportunity and time to exert our clarity on the areas that are going to be presented on. We're also welcoming those that are participating, our media component, on this important discussion on the electoral reform. I'm going to invite Mr. Matonsi to give us apologies and also introduce our staff members from Parliament who are here, and then invite the Minister of Home Affairs to introduce his team, and also invite the IEC. Mr. Matonsi will guide me if the chairperson, Commissioner Mashinini is here, but I recognize Commissioner Love. They will guide us and introduce the team. The IEC is here just to listen to the interaction and the presentation of the minister and the team. Mr. Matonsi.
Hi, Chair. Thank you. On the apologies from members of the committee, I only have got Ms. Lefase, who's in the meeting at the moment, and then she's going to leave at 10 o'clock. That's only one apology. In terms of the staff that is attending the meeting, we do have here from Parliament Legal Service, we have got 3 legal advisors. One is Mr. Sivu Njikela. Then the second one is Mr. Elana Hali. The 2 are going to be assisting us on the issue of the minister's bill in terms of giving advice. Then the 3rd legal advisor is Ms. Daksha Kasen. I'm sure the members are familiar with her. She's going to be assisting us with the issue of the private members bill. Then from the state law advisors, we have got Ms. Sureya Williams and Ms. Sarah Govender. The 2 will be assisting the committee in providing advice on the minister's bill. And then the other colleagues is the researcher, Mr. Pakamile Fungwani, Adam Salmon, we are familiar with him. The content advisor, we've got Nangipa as well. We've got another colleague, Mr. Dolan Ranto from the Select Committee on Security and Justice. Is here because this bill is to go to the SOP at some stage. I think that's all, Chairperson, from my side.
Thank you, Mr. Matonsi, for the apology rendered and introduction. Mr. Matonsi, are you talking?
No, I'm done, Chair. I'm done, Chair.
Okay.
Okay.
Is there any other apology members who must note? Thank you. Minister, you are invited to introduce the team and also the IEC. Minister Mutsolid.
Yes, good morning, Chairperson and members. Compliments, because I assume the Portfolio Committee is meeting for the first time this year. Thank you very much. I hope you are all refreshed to start this work, which definitely is going to need all our energies, because we must finish it within as short a possible time as possible. Chairperson, I will introduce the DG, who will introduce the staff from the department. From the Electoral Commission, yes, we've got the Deputy Chair of the IEC, Ms. Janet Love. I will also leave it to her to introduce a team. So can I start with the DG, who will also introduce the legal team of the Department of Home Affairs, the Senior Counsel and his team, who are going to present to us today. DG, please.
Good morning, Chair. Greetings and compliments to the members of the Portfolio Committee as well. From the Department of Home Affairs, and good morning to the Deputy Minister and the Minister as well. So from the department, we're joined by the following DDGs, DDG Jackson McKay, responsible for immigration, DDG Tulani Mavuso, responsible for institutional planning and support, DDG Thomas Sigama, responsible for civics, and DDG Advocate Constance Muitsi. She was responsible for counter-corruption and security services. And then our CIO, Mr. Ntlantla Mabaso, responsible for information services. And then we also have the Chief Director responsible for strategy, planning and policy, Mr. Sitle Tiane. And then from the ministry, Mr. Muzi Njokwe, who's joining as well as a parliamentary liaison officer, Lady Makua. And then the Chief of Staff, Mudupi Maisela Kamtuli. Sia Koza is the Minister spokesperson, and also we joined the chair by the new Chief Director for Communication at Home Affairs, Mr. Bongi Kwala, who's just joined us. And then there's a team that's led by Advocate Stephen Batlender, Senior Counsel. I'm not sure if you are there, Senior Counsel, maybe just for the Portfolio Committee to see your face. Advocate Stephen Batlender.
Good morning, DG, and good morning.
That's Stephen.
Good morning, members.
Okay, Stephen is joined by three junior counsels, Fundo Salugazana, Michelle Dipie, and Salume Manganye. They've been working quite hard with the senior counsel around this bill. I'm not sure if they are also online, just to show their faces as well.
DG, I know some of them were going to join late. They had other commitments, but would join late. But they're all aware of it. Thank you, DG.
So that's Michelle. All right. Thank you, Minister. That's the team from our side, and back to Chairperson. Thank you.
Thank you, Minister and the DG. Commissioner Love.
Thank you very much, Chairperson, and good morning to you and to the other honourable members. Also, good morning to the Minister, the DG and the team and the legal team. On behalf of the Commission, let me also wish everybody the best for 2022. I want to just convey, first of all, the apologies of the chairperson and the other commissioners. I'm accompanied today by the DCO Shiburi, the CEO and the other commissioners and members of the commission are currently engaged in a meeting which has been established to take place for some time. And so I convey their apologies, but obviously we will be feeding back to them anything from the meeting. Thanks, Chair.
Thank you, Commissioner Love. Minister Braedi. We are now going to invite the Minister to introduce the presentation, and he will delegate to the team if necessary. Then we'll then after have interaction with the comments from members of the committee, and then we'll go to the other item to deal with the comment from the Minister on the private members bill presented by Honorable Quota. Minister Mtsoaledi.
Sorry, Chair, before the Minister comes in, can I just confirm that the presentation is being displayed? It's Adam here.
Yes, Mr. Adams.
Thank you.
Yes. Thank you, Adams.
Yes,
thank you, Minister. You can proceed.
Yes, thank you very much, Chairperson. And once more, thank you, members of the Portfolio Committee, the IEC, and leaders of political parties outside the Portfolio Committee. Thank you for this opportunity. Chairperson, as we have already said, I made this presentation to a full Portfolio Committee on the 7th of December 2021, and I provided information to you about two issues. The Ministerial Advisory Committee report, who constituted the Ministerial Advisory Committee, what was their report, and the second thing, the Electoral Amendment Bill. I presented the features of it and how it is going to work. At that time, when that happened, the Office of Chief State Law Advisor had not yet certified the bill, but on the 2nd of December, they provided the legal opinion on the constitutionality of the electoral bill, and subsequently it has been certified. So that hurdle, we've gone through it. I mean, we've gone over it. The bill has been certified, and I'm sure I heard the DG saying the team here from the Office of Chief State Law Advisor are also here to put clarity on issues. And as it was said, on the 10th of January 2022, I introduced the Electoral Amendment Bill to put the National Assembly and National Council of Provinces by right to the speakers and sending the bills to them. What is left is for this committee to take the bill and run with it. And I believe today's process is to start that. Just to recap, can we go to page 6 of this presentation? Because I can't repeat the same presentation. Just to recap where we were. Can we go to page 6 and skip all the other things, papers and all that? Yes. You will remember, if I have to recap, that I presented to you that the Ministerial Advisory Committee presented to us two options. What is called the minimalist option, whereby we modified the existing multi-member electoral system to accommodate independent candidates in the national and provincial election without many changes in the legislation, including not interfering with the constitutionally required general proportionality. That's what the minimalist option means. The other option, which was provided to us, was the first past the post and proportional representation, making it a mixed member proportional system, representing exactly what is currently happening in local government, where we have got constituencies, which we call wards, but we also have proportional people which are sent by political parties. That's what is called a mixed member option. Of course, this one will be done with some improvements over what local government is doing. Now, I told you we took these options to cabinet. Cabinet chose the first option, the minimalist option, and that is the option I presented to you, if you remember, on the 7th of December. Now, in that option, I went with you through how the country is going to have regions, which are the present provinces, which will be multi-member constituencies, where a lot of people will stand, both political parties and independence. And I went on to show you how we determine the seats by allocating the seats in 3 tranches, whereby the first 2 tranches are for the independents, and the last one is for political parties, where we use a Droop method. And I presented that to you. Then from there, I told you that the bill exists, which will actually show these things in the form of a bill. And I showed you at the end that this whole option entails a consequential amendment of the party funding bill, which has just been in operation from last April, if I'm not mistaken. That party funding bill is forcing us to consequently amend it to be in line with the Electoral Act amendment, when we amend Act number 73 of 1998. Now, Chairperson, I don't think I should go through this process again, which I've shown you in numbers, how we allocate the seats. Here today, I think we need to deal with issues that are sort of sticky points of debate, which I'll do especially when I deal with the bill sent by Honorable Quota. The sticky points are the issues of the court judgment vis-a-vis membership of independent in the National Council of Provinces, NCOP. The second sticky point is about the allocation of votes in the 2 tranches, whereby if you are an independent, after you have reached your quota, the other votes won't count, just like it's happening in local government now. As far as the wards are concerned, you are aware that independents who win a ward, their votes are not necessarily going to count when we do proportional representation seat. This is what we have proposed, and some people were sort of questioning it. Those, I think, as far as I'm concerned, are the main sticky points which needs to be devised, which needs to be dealt with today. Now, at the end of the presentation by Advocate Bartlender, I'm going to come in and try to give the differences and the similarities between the bill presented by Honorable Quota and this bill presented by the Department of Home Affairs. But for now, I think in order to take the process forward, Chairperson, this presentation on the screen is exactly a repetition of what I presented to you on the 7th of December. It's just that it might be presented a little bit differently. If you move to page 14, for instance, can you move to page 14? Yes, I demonstrated to you exactly how the seats are going to be allocated, making use of what happened in Gauteng in the previous elections. The number of, the population, the number of people registered, the number of seats as determined by the Constitution, etc., etc. I don't think I should go through that. Page 15, I think it's more or less the same thing. So what I'll do, let me give to Advocate Bartlender to take you section by section through the bill and show you what is that which they've actually put in the bill. And then from there, I'll come back and show these similarities between the bill, private members bill, and the bill presented by Home Affairs. Thank you very much, Chairperson.
Thank you, Minister. We'll at this moment invite the Senior Counsel to take us through.
Thank you very much, Chairperson. Could I ask for the next slide, please? And let's go forward until we get to the clauses of the bill, please, in the presentation. Thank you.
I think you must start in page 17.
Yes, thank you very much, Minister.
Yeah.
So this is the presentation of the overview of the bill. If you would go to the next slide, please. And the amendment of the bill really does 2 things, and perhaps I can just give an overview. Obviously, it produces for the first time the ability for independent candidates to run for the National Assembly and the Provincial Legislatures. And I'll take you through how that works in a moment. But as a consequence of that, various consequential amendments have got to be made regarding forms and time periods and definitions and those sorts of things. And I'll take you through those as well. So if we could go to the next slide. You'll see that it provides for the nomination of independent candidates. It provides for the requirements and qualifications that have to be met by those candidates. It provides for the procedure that must be followed if there's a non-compliant nomination. We can go to the next slide. Provides for how the inspection of the lists of independent candidates will work, how people can object if they think an independent candidate is not qualified, how the list of independent candidates will be published. It ensures that independent candidates are bound by the Electoral Code of Conduct, just like political parties are. It provides for deposits to be returned to independent candidates if they're elected, and I'll come back to that in a moment. It amends Schedule 1, which deals with the mechanics of the election, and Schedule 1A, which deals with how the seats are allocated, and that's really where most of the work of the bill is done, and I'll come back to that in a moment. So if I could begin with Clause 1. Clause 1 is really and I apologize for reading off this other screen, but I need to keep the bill with me. Clause 1 really deals with the definition points. It inserts a series of new definitions regarding the definition of independent candidate, the definition of candidate as opposed to an independent candidate, a list of independent candidates, province, and a region. I don't think I need to spend time on that. If there are queries, of course, we can take them in due course, but I don't think there's anything particularly controversial or noteworthy there. Then Clause 2, it amends Section 27 of the Electoral Act and provides that if you want to appear on the regional list of candidates or a provincial list of candidates, you have to sign a declaration that you are located in the province in which you are running. So let me just explain that for a moment. The approach adopted in the bill is to say that when you want to be elected from, let's say, Gauteng to the National Assembly, in other words, on what we used to call the province to national lists, or what are now called the regional lists, you need to be living in Gauteng at the time. Just as works in the local government context, where you have to live in the local area concerned. And so Section 2, or Clause 2, amends Section 27 to provide for that. And that will apply equally to candidates who want to be elected on those regional seats for political parties and candidates who want to be elected as independent candidates. If we could go to the next. Clause 3 then is just a consequential amendment, and it simply refers back to Section 27CA and says you've got to comply with that. So I won't spend time on that. Clause 4 is more substantive. Clause 4 is the clause which makes provision for the first time for the nomination of independent candidates. And what it does is it inserts Part 3A in Chapter 3 of the Act, and that includes Sections 31A all the way through to Sections 31F of the Act. And if I could deal with each of them briefly in turn. Because what we're doing here is we're explaining or setting out the basis upon which people may be nominated as independent candidates. The first thing I would draw your attention to is in section, if you could leave it on the previous slide. Thank you so much. The first thing I would draw attention to is that in Section 31A, which is a new section which was included, it would require that in order to run for a provincial legislature or for the National Assembly, you have to be located in the province in which you are running. You have to be ordinarily resident in the province in which you are running, and you have to be registered as a voter in that province. And that, as I say, is consistent with the approach that Parliament has already taken in the local government elections. Section 31B then deals with the requirements, and this is all under Clause 4. Section 31B then deals with the requirements and qualifications for independent candidates. I would just draw attention to a few aspects. The first is that there's obviously a problem if there are too many independent candidates. Let's say, for example, there were 200 or 300 or 400 independent candidates running in a particular province. You're then going to have a ballot paper that is going to run to 300 or 400 entries, many, many pages, which is hugely expensive, but also potentially very confusing to the voters. And so there's a need for appropriate thresholds to be set, again, just like in local government, before you can be nominated as an independent candidate, you have to meet certain thresholds. And what the bill provides is that you will need to obtain a minimum number of signatures and pay a minimum deposit. And the way it works is that it's left to be prescribed by regulation what the minimum deposit and the minimum signatures will be. And that, of course, is regulation by the Electoral Commission, because the Electoral Commission makes regulations under this Act. There will also need to be various other declarations confirming that you're qualified to stand, that you're not prohibited from standing. And one which is worth drawing attention to is the one at 31B3, section 31B3F, which says that there will need to be a declaration that you have not been a member of any political party for at least 3 months preceding the date of the nomination. And the idea behind that is the principle that if you want to run as an independent, you shouldn't be associated with a political party. The whole point of the Constitutional Court judgments is that people should be able to run without being associated with a political party. And the 3-month cutoff is the idea that people should make their decision well in advance. Are they going the party route or are they going the independent candidate route? The next section as part of Clause 4 is Section 31C. You can just, I'll let you know when to move the slide. Thank you so much. Next, Section 31C, which deals with non-compliance. It simply says that if you don't comply with all of these things, you can't be nominated as an independent candidate, and it sets out the process whereby there can be an objection and the Chief Electoral Officer can rule on the objection. 31D then speaks about the inspection of copies of lists of candidates and accompanying documents, and that's simply to make sure that the documents are made available for the public to consider and so that they can lodge their objections. 31E deals with the objection process and says how you can object, and 31F deals with the publication of the lists of candidates. So really what's set out in that clause is what you've got to do to qualify as an independent candidate and the mechanics for going through it. Could I then move to the next slide? And the next slide deals with Clause 5, and it is an amendment to Section 57A of the Act, and it simply provides that the way people will be elected will be from lists of candidates, which means candidates of political parties, and lists of independent candidates. So it's a small change, but is necessary in order to apply the amended Schedule 1A, which is where the work is done, and I'm going to come to that in a moment. Then clauses 6 and 7 I will deal with together. Clauses 6 and 7 deal with the Electoral Code. As you know, under the Electoral Act, there is a code which all political parties are required to comply with, and this provides that the Electoral Code will also apply to the independent candidates, and that the independent candidates must commit to applying and complying with the code before they can be registered. So that deals with clauses 6 and 7, which amend sections 94 and 99 of the main Act. Thank you. So Clause 7 I've dealt with. We then come to Clause 8, and Clause 8 deals with the amendment of Section 106 of the Principal Act, and that's the refunds of deposits. So as I explained, just as with political parties, independent candidates will have to pay a deposit in order to contest an election, and the way it works under the existing system is that if you succeed in the election, you are elected, then the deposit is paid back. Same here, Clause 8 amends Section 106 to provide that if an independent candidate is elected, that independent candidate will be able to be refunded that amount. So that is Clause 8. Then if we could go to Clause 9, Clause 9 amends Section 110 of the Act. Again, it is just about the lists, and it provides that any mistake in the certified segment or the final list doesn't invalidate the voter's roll, just as is works with political parties. So again, it's an attempt to very much equalize and put on the same footing independent candidates and political parties. Then we come to Clause 10. Clause 10 deals really with the electoral timetable, and the electoral timetable set out in Schedule 1 and the processes that are set out in Schedule 1. And the processes are simply adjusted to make provision also for independent candidates, because of course at the moment they only deal with political parties. So I won't spend time on the detail because it's really just consequential amendments to make provision for that. And then we come to clause 11, which is, as I say, really where the work is done, because the members will know that the process for allocating votes and electing members is dealt with in Schedule 1A of the Act, and it's that schedule which has been amended in material respects to allow for independence. Because there were so many amendments, the schedule has been substituted rather than simply adjusting words here and there. But much of what is there is still consistent with the existing principles. But I will now take you through the relevant provisions of Schedule 1A as amended. So you will first see, and you can leave it on this slide, thank you very much. You will first see, and it links, let me say immediately, it links to the presentation that the minister gave in December last year, and the slides which are part of this presentation, which the minister flipped through. It explains how that all works. But just by way of brief overview, items 1 through to 16 deal with the allocation of seats in the National Assembly. And that is on the basis that the minister explained in the last address, and on the basis that the presentation explains, which is effectively there are 200 seats which are regional seats. Again, you will know that under the existing system, those are what are called sometimes provincial to national seats. So the way the existing system works is there are 200 seats which are elected truly nationally in the National Assembly, and there are 200 seats which are elected from the provincial to national list. So Mpumalanga sends its people elected from the Mpumalanga list, people elected from the Western Cape list, etc. This will be the same system, 200 national seats and 200 regional seats, which is what it's called to avoid confusion. And those 200 regional seats will allow for independents to be elected. And the way it works, as the minister explained previously, is that everybody will vote. There will be a single ballot for the National Assembly in each province, but the ballot might be different in each of the provinces. So for example, if I'm running as an independent candidate in Gauteng, and Mr. Smith is running in an independent candidate in the Western Cape, then the ballot in Gauteng will have to include my name, but won't include Mr. Smith's name, and the ballot in the Western Cape will include Mr. Smith's name and not my name. So there is at least potentially 9 different ballots, one for each province, for the National Assembly. Obviously, the political parties will appear on all of those ballots, but the individuals who are running for election to the National Assembly will only appear on the ballot of the province in which they are running. So we will all then go and vote, and when the votes are tallied up, the votes will be tallied by means of calculating how many seats that province has in the National Assembly, and that's done, as is the existing practice, by the Electoral Commission based on the population. And that will determine the quota that will be used. And members will recall the discussion of the quota. So there will be a quota which will be used, and we gave the example of the Gauteng Provincial Legislature, but the quota will be used, and depending on how many votes are cast and how many seats, the first round of allocations will be to the independents. Once the ones who meet the threshold will be elected, they will then be taken out, including all of their surplus votes. Then there will be a second round of allocations, again to the independents. Those who meet the revised quota, which will be lower, will again be elected. They will be taken out, as will all of their surplus votes, as will all of the rest of the independents who haven't made the seats. And then the third round will be to the political parties. And that system has been designed to make sure that independents are given a proper opportunity to be elected, but also without disadvantaging political parties, because the system doesn't work to the disadvantage of political parties either. If the threshold was 50,000, the political parties will always get 1 seat for each 50,000, and possibly more depending on how many surplus votes get taken out. And it makes use of the existing quota system, which is called the Droop Quota. I can go into the details in due course if needs be. But in essence, the point is there are 3 rounds of allocation. The first to independents who make the quota, if any. The second to independents who make the quota, if any. And the third to the political parties. If no independents make the quota, then of course the political parties will simply receive all the seats. So that is the way that the system works in relation to the allocation of regional seats. The one thing that I should draw attention to is, well, in fact, I'll come to that in a moment. Then we come to the provincial legislatures. That is dealt with by clauses 17 through to 23. You can leave it there. It's all dealt with by clause 11. It's dealt with by item 17 through to clause 24. And again, it's a similar system whereby in the province, there will be a ballot paper for the election to the Western Cape Provincial Legislature or the Northern Cape Provincial Legislature. That ballot will have all of the political parties running for that legislature and all of the independents running for that legislature. And so if I choose, instead of running for national as an independent, to run for the provincial legislature, my name will be on that. The same process will be followed. There will be the same allocation. First seats to the independents, if any make the threshold, then again to the independents, and then to the political parties. But again, I want to emphasize that that doesn't in any way disadvantage the political parties, because the threshold that will be used will not disadvantage the political parties. It provides a fair balance between the needs to allow independents to be elected, but without disadvantaging political parties. Then item 25 of the clause deals with ballot papers, and it deals with the clause the point that I've already made. There will be different ballot papers for each province if there are different independent candidates running in each province. Items 26, 27, 28, 30, through 31 and 32 are really consequential. They're about the publications of lists, and it simply is very much a mirror or an adaptation of the existing provisions. Item 33 is worth remarking on. Item 33 deals with vacancies in seats allocated by a political party, and of course it allows the political party to allocate a replacement. So if Mr. Khumalo was elected by the ANC from its list and Mr. Khumalo leaves or dies, the ANC can replace Mr. Khumalo. But then item 34 says that if Mr. Smith is allocated a seat as an independent, in other words, he was elected as an independent and he leaves or dies, then the seat will not be filled until the next election. And the need for that is because otherwise there is the risk of very frequent by-elections, and the by-elections, because of the way the system works, would have to take place province-wide. So every time an independent person leaves, you would have to have a province-wide by-election, which would be extremely disruptive and costly. And so in the circumstances, item 34 says that the seat will remain vacant until filled in the next election. And then item 35 just deals with certain amendments to the definitions in respect of the schedule. So that then covers clause 11, which amends schedule 1A. And then finally, clause 12 simply contains the name and title of the act and provides that it will come into operation on the date fixed by the President by proclamation, as is standard practice. Chairperson, Minister, that's a summary of the bill clause by clause, but of course I can answer any detailed questions should the need arise in due course.
Thank you very much for the summary of the bill that you ran on clause by clause. We did receive the detailed brief last year presented by the minister. I'm going to invite members to comment on the brief, also raise questions when they do their comment. We have Honorable
Chairperson,
Minister.
I've got a proposal with apologies, Chairperson. For members to be able to raise questions, is it not good that they raise them in comparison? I'm just proposing, if I'm out of order, please tell me immediately, that I present the comparison and the difference between what the Electoral Quota bill is proposing and this bill, so that when members discuss, they discuss them together. I don't know whether that won't help the process.
In fact, Minister, it would be best to deal with them separately.
Okay, fine.
Because you will be attempted to comment on the executive bill that has been presented. At least when the members have interacted or comment, yourself and the senior counsel will assist on the responses and comments.
Okay, thank you.
Yes. Well, I'm going to invite Honorable Mulder, Honorable Groenewald, Honorable Mulekwa, Honorable Ross, Honorable Lokota, Honorable Kanyile, Co-Chair Honorable Merve, Honorable Tito, Honorable Pile, and Honorable Mutise to make questions and comment. Senior Councillor, I also want just to check. I hear that on the closed, you have referred that once there's a vacancy on the new, there won't be by-election. I think the reasons are you have motivated. What will happen in the period with the constituency responsible if the vacancy is going to be occupied in the next elections? Our elections go for 3 or 5 years. What will happen? I want just to take us through what will happen with the constituency responsible for who have elected Honorable Ross to represent them in Parliament and as an independent. But I get the sense, but I just want to empower that that area. In that order, Honorable Melda. Honorable Groenewald.
Thank you, Chair. Chair, firstly, from my side, thank you for the opportunity. I'm going to be very short. I went through all the documentation, and I think what is important that we must comply to Section 46 of the Constitution that actually determines that in the end, if we look at the National Assembly specifically, that the result in general must be proportional, and that's what I find in this proposal. And from the Freedom Front Plus's side, I want to say that we don't have an objection with the road, and can I say the direction of this amendment bill in terms of allow independent candidates also to participate. They have that opportunity. I am of the opinion that, but that is a debate not in this committee, that people always think that an independent candidate will be more accountable to the electorate. I am not convinced that that will be. I know that if you look at electoral systems all over the world, one of the features of, for instance, a constituency electoral system with first past the post, people think, and yes, it is a feature, that there is in a certain sense more accountability for the people. But I also want to stress that you can get right exactly the opposite. For instance, if you have an independent candidate in a constituency, then there is no control over that specific independent candidate. And I think we have the examples, if we go to our local government elections. I mean, a ward is nothing else than a smaller constituency. And there are many independent candidates in those wards. But that besides that, I want to say that the Freedom Front Plus, if we look at the proposals as it is at the moment, we will support it. Thank you, Chair.
Thank you, Honorable Groenewald, for your comments and on the matter. Honorable Mulekwa.
Thank you very much, Chairperson. Let me start by also appreciating the presentation as being presented today. And also, I want to appreciate the team for its daily work and the progress made so far in making sure that we receive this presentation, a comprehensive one today. Chairperson, I also appreciate the fact that the committee has made available the option for this PEC to be able to determine which way should be taken in terms of the amendment for the Electoral Act. So I just want the committee or the minister to clarify more. For instance, if the portfolio committee can decide or can recommend that maybe the option 1 is the one we should go for. So what will be the consequences and what are the consequences of option 2? But for me, Chairperson, I think we appreciate the report and welcome the report as presented. Thank you.
Thank you, Honorable Mulekwa, for your comment. Honorable Ross.
Yeah, thank you, Chairperson. Chair, I think, the challenge, part of the challenge is that we kind of been put between a rock and a hard place here. We have 4 months until the 10th of June, 2022. And today we'll be asked to make a declaration on the second bill that we're going to consider. But really there's still a few things that I believe that we need before we can consider this properly. And the first thing is that, we talk about constitutional or constitutional muster and whether one bill or the other passes constitutional muster. My question is, has this bill been assessed against the Constitutional Court judgment and the requirements by our parliamentary legal advisors or the relevant legal advisors, to ensure that we don't have a legal challenge to it? Because it's, we can go through the whole process of analyzing and passing legislation and that, and it's so contentious that we can end up in a situation where the legislation is then challenged against what the Constitutional Court has said. So that's something that we'd like to see, Chairperson. And then secondly, Chair, I believe we should have the implementation timeframes. These were presented during 2020 for various different options. And I truly believe that if we need to look at different options as amended and which of the options is the correct way to go, we need to get these timeframes again. We need to see where we are at now and how this will be implemented within the Constitutional Court deadline. And that includes the Political Party Funding Act and the changes to that would ensure a fair election, that political parties and independent candidates can campaign on the same financial footing. And particularly public participation, Chairperson, I think in previous amendments to electoral legislation, that is something that has been heavily criticized, meaningful public participation. So we're not talking about putting out an announcement and then persons that have access to the internet and email and that kind of thing can submit, and the rest cannot. This is absolutely critical legislation from a national point of view, from the public interest. And I believe as a committee, we need assurances that we will have a meaningful public participation, whichever option is taken at this point in time. And then some questions in terms of the bill. I think the first question is really looking at the minimalist option. Why was the minimalist option taken? Because it seems like the government's policy is to try and govern at a district level, but then there seems to be a reluctance to have a constituency level electoral system whereby those representatives can be held accountable at a more local level. I just want to understand, my understanding was that this was also agreed at sort of a political level as well as where we find ourselves now. But I just want to understand from the minister's point of view, the disjuncture between how the government wants to manage the country and on a district level, but then doesn't want to align the electoral system to that from an accountability point of view. Secondly, in section 1, we're talking about a region. I just want to understand why we're not talking about a constituency. Is there a specific meaning to a region and using that terminology? And then in clause 9, just in terms of provisions, are there provisions to correct mistakes on the final voters roll that are not, or that are the fault of the IEC? I think we found in the last election that there were several persons that attempted to register, and for whatever reason they found once the voters roll came out that they were not on there, and then it was too late. So I want to understand what provisions will be made to prevent this in the future. Thank you, Chair.
Thank you very much, Honorable Ross, for your comment. Honorable Quota, Veteran Quota.
Thank you, Chairperson. Can you hear me, sir?
Yes, proceed, Veteran.
Yeah, thanks. First of all, Chairperson, I would like to ask the question, if the independent candidates, if they pass away, then there's no by-election. How do the constituents, the people who live in that area, how do they deal with their problems? Already at the present time, if you look into our provinces, if you look into our localities, there's a complete neglect of the conditions of life of the people. And so if you have to wait for another 5 years before you can have a replacement, how do you deal with your problems in the intervening period? I really would like to hear how that is responded to. We hold the view that this clause in the Constitution is particularly important because it provided in the Freedom Charter that the people shall govern. And if now, when people have voted, a large number of votes are thrown away, I can say that they are thrown away because they don't, for independence, those votes account for nothing. The people who voted for the independence, they gain nothing for having voted in big numbers. How do we say the people are equal? Where is the equality clause? Some people will vote for the parties. In fact, this clause is, well, this step of getting rid of votes is a very much compelling that people must only vote for political parties. If you throw their votes away, how do you make up to them so that they continue to have a voice that protects them, that enables them to ensure that they can demand attention from those for whom they have voted? I really would like to understand that, because as far as I'm concerned, this particular step eliminates equality between citizens. There are some who will have more rights because they have voted in numbers for parties, and others who will not have those same rights. I think that there's a serious failure to meet the constitutional muster here. And certainly, very many of us who will come to terms with that must challenge this, perhaps go back to Constitutional Court and say, no, we are not enjoying equal rights. The Constitution is still being violated. Thank you.
Thank you, veteran. I've carefully went through the two provisions of the members' private bill and the executive. It will be interesting when the minister is going to look on the matter that has been raised now. Honorable Kanyele, thanks, veteran, for your comment.
Thank you, Chairperson, and good morning, colleagues. We are noting the presentation, and however, I'm having just a few questions here. I think I have been partially covered by Honorable Likota, but I also have a question similar to his with regard to a candidate, that when a candidate resigns or their position becomes vacant, there's not going to be a by-election because the presenter mentioned that the cost is going to be very expensive. So my concern is that does that mean now that constituents will have to be without a representative for the whole duration of the term, because the provincial legislature and the National Assembly term duration, it's actually 5 years. So what if that candidate resigns within the first year? So it will mean for the rest of the 4 years, the voters are not going to have a representative. I feel like the service delivery is going to be affected, and also those members that would have voted, their issues are not going to be escalated properly. I do believe that we need to find a way to look into that. Also, there's an indication that if a member needs to participate or wants to participate as an independent candidate, they must not be associated with any political party for 3 months or more. I think the presenter indicated that it will give them ample time to decide on what they want to do. The question that I have is that in an instance where the political party that they are a member of does not want to accept their resignation, what impact is that going to have on their candidate? Another question that I am having, it is about, could you please just hold on for me? It is about the deposits that is paid to the IEC. I want to know that what criteria does the IEC use to determine that the candidates that have won the election, they're going to be paid back their deposits, and the other candidates that did not win the election, they're not going to be paid their deposits. I think those are all the questions that I have for now, Chairperson, and thank you so much.
Thank you, Honorable Kanyele, for your contributions. Honorable Van der Merwe.
Thank you very much, Chairperson, and greetings to you and to our Minister. And it's nice to see all the colleagues again. And thank you very much to Advocate Budlander for his presentation. I'm not going to be very long, Chairperson, because I think the colleagues that spoke before me has adequately addressed some of the issues. However, Chairperson, I want to just reiterate what the Honourable Roos had mentioned. I'm not quite sure with the 4 months that is left for us to process this bill, how we will actually do justice to this mammoth task that lies ahead. Because firstly, the public comment period will only finish or will close at the end of February. Then we still need to embark on a public hearings process. And I assume with this bill being such an important bill to the public and to South African citizens at large, that we would need a lot of time to be able to process these public hearings in order to be able to do justice to this project that has been put before us. And considering that the bill will have to come back to us as a committee where we will have to deliberate on the changes or suggestions of South Africans at large, I just do not see how it then goes to the National Assembly and to the NCOP within a 4-month period. So I would really like to ask, what are the implications with regards to us not meeting this 4-month deadline? Will we have to seek a court extension? And also possibly the implications of that on the 2024 elections, because at the end of the day, if we don't meet the court deadline and we have to seek an extension, these changes that we're seeking to make will not be an overnight process. So it might not then allow independent candidates to stand in the 2024 elections, but maybe, That's just a comment and maybe a question if the minister wants to answer to that, because at the end of the day, the public participation process will be very important. We need to be guided by South Africans as to whether these amendments that we're putting before them are what they want to have or not. And there's already been some issues with regards to the perceived fairness of this amendment bill. Chairperson, yesterday, for example, I heard some commentators suggesting that what we are seeking to do is to keep big political parties in power and only accommodating independent candidates by simply adding them and not giving them a fair chance to compete. For example, if you look at the issue of money, etc., money is the milk of politics. It will be difficult for many independent candidates to compete against political parties. So we really need to take the issue of fairness and equality very seriously here. So I also wanted to ask the question in terms of region. I want to ask currently, how is the term region currently understood? Well, the issue of region must be clarified. Is it currently defined? It's currently defined as a territorial area of a province. And how does it differ from a ward council or a constituency? And how is the term region currently understood in terms of the current system? Is it interchangeable with the term province? And if region means a province, will all provinces or regions be allocated the same number of seats? For instance, will the Northern Cape, which has a population of 1.2 million, be allocated the same number of seats as Gauteng, which we know is a much bigger province? So please can I be given more details in terms of how we will allocate these regional seats? And then also, I think, Honourable, I think the two issues around the discarding of the votes and an independent candidate resigning or leaving office is an important issue, because firstly, I did hear the minister in December saying, the issue of discarding votes is an international practice that happens everywhere. But you see, in our context, with every vote counting and every vote being of such importance, coming from where we come as a country, discarding votes at the end of the day might influence the fairness of the election. In other words, the outcome of the election might not be the will of the people. So we need to find a way in terms of how we will deal with the issue of discarding votes. Is there not another mechanism, in other words, where these votes can be transferred to another independent candidate? Or I'm not sure what the solution will be, but specifically also with regards to an independent candidate leaving office or passing on, it can't be that seat remains vacant for such a long. So I think those two issues are something that we need to consider. And of course, I want to really, emphasize that I do not see how we do justice to this process in 4 months. Thank you very much, Chairperson.
No, thanks very much, Co-Chair, for your contributions. Honorable Tito. Honorable Tito. Honorable Pillay.
Thank you very much, Chairperson, and greetings to all members. Chair, firstly, I think it's important for us to commend and congratulate the work that has been done. We have come this far, and we're able to present what has already been completed. However, there is a process that needs to be followed. And for me, I think it's important for us to see how we take this process forward. And Chair, I want to propose that we get cracking with that, especially because we are limited in terms of time, and how we can now open that process up for public consultation and to be able to then get inputs. And obviously we'll cross that bridge when we get there. I think that we must be able to continue the work that we need to do. And if by the second or third month we see that we are still having a challenge, then we can be able to deal with it. But right now we still have 4 months. And I think it's important for us to get work done. But yeah, I want to comment very particularly in terms of the surplus votes being cast, discarded, or votes being transferred. I think it's important to first understand what is independent and what defines an independent candidate. It's one person. It's an individual that contests the space as an independent candidate. If the individual or candidate wanted to contest the elections as a political party, they will then form a political party, or they'll get all independents together under one umbrella that forms a party. In this instance, it's one person contesting the space. Hence, you cannot take votes that was cast for that individual to anybody else, be it another independent, be it another political party, because the will of the people was that the vote was cast for that individual. For example, if I was an independent, the vote was casted for me. My votes then cannot be given to anybody else. I think somebody is interrupting my... Thank you very much.
Yeah, proceed, Honorable Pile.
Thank you very much, Chair. So if that was the view of my constituency or people who wanted to vote for me as independent, it meant that they cast the vote for me only. I can't then just say that the votes must be given to anybody else because they didn't want to. If they wanted to, they would have voted for somebody else. So in the same instance, after you meet a threshold of getting a seat, there's nothing else that can be done with your votes because it can't go to anybody else. Hence the reason for that. And I think we've gone through this, we've discussed it. And Chair, I want to propose that we must now move. Let us agree as a committee what the timelines are and what is the process that we're going to take in the next few months and how we're going to then implement the plan that we have in terms of the rollout. Thank you very much.
Thank you very much, Honorable Pillay, for your comment and contribution. Honorable Modise,
Thank you very much, Chairperson. Let me take this opportunity and appreciate the Senior Council for the work that they have done with the team, which is led by the Minister, having had developed this important bill. We know that we would have had limited time towards the end of the year to finalize it up to a process that led to the publication of the bill or the presenting the bill to Parliament. So let me take this opportunity and appreciate the team. Indeed, we have come this far. It is a fact, and I think we are all concerned with regards to the time frame. For me, there is a great need for a broader consultation with these amendments to the public, and that would need us to have sufficient or adequate time to afford the public to participate and make comments, so that we as a committee are then be able to deliberate on the issues and get guidance from the public. So indeed, the 4-month time frame, it is worrying. I would want to suggest, Chair, that we probably need to get a counsel from the legal team of Parliament with regards to the legislative processes of undertaking the bill or the processes that come thereof with processing the bill, so that we can then start weighing our options as this committee on with regards to the time frame that we have of June to complete the process of the bill. We all agree that we really need to engage the public, and thereafter will be also need to afford the IEC to do its work post the adoption of the bill by Parliament. Therefore, my suggestion, as the latter speaker would have mentioned, the co-chair Lizelle, that the 4-month time frame might not be enough. We still do have an option of approaching the courts with regards to there's limitations. We cannot approach the courts after we've or at a short notice. The courts will not afford us an opportunity to or a postponement or an extension. If we would want to wait up to the last minute, it would seem as if we are really sinister and do not want to process this bill properly. So I would suggest that, Chair, as soon as possible, we need to take a decision as a committee on a way forward on how we move. But of course, we do not need to now start considering requesting an extension without embarking on a process. So we need to start with the process and continue and do work whilst we also are weighing our options and whilst we get counsel from the legal of Parliament. I do not have comments on the bill itself. I think members would have sufficiently asked questions or seek clarity. Chair. My concern also is the fact that I strongly feel that it's an important bill and it needs to be taken to the public, and we do not need to have a very short time embarking on that process. It will really need time. Therefore, we need really to look into that as a committee. Thank you so much.
Thank you, Honorable Mudisemta, for your contributions. I've earlier on invited Honorable Tito. I think she was not on the line. I'm not sure if she's back before we get into the responses and comments from the team. Honorable Tito? Okay. I was going to invite the team to comment and respond to the issues that have been raised by members. And in the main, I think it's way forward on the issues that you need to respond to. The other matter which I'd advocate, perhaps you may need also to add in your response, is that you have two houses, the NCOP and NA. And how are we going to deal with this process of accommodating the independent? You know that the NCOP delegates nominated by provinces. So I wanted your impression around that with the minister in terms of the issues that are arising. We're going to invite, if there's a comment from IEC, I know they're here on the observer status because they still have to interact with this process post the adoption of the bill. If there's comment, they can come in, and then I'll invite the advocate, I'll invite the deputy minister, and I'll invite the minister to also comment, and then we will close. Commissioner Love, is there any comment, or you want to observe your status?
Chair, thank you very much for that. I don't think that we have specific comments in relation to what has been said. There was one question that was directed expressly to the IEC, which is how the IEC sets the threshold of refunds. I think just on that, and I'm sure Council will then also weigh in, the IEC doesn't. At this stage, the legislation provides for the fact that the IEC must set a threshold, and clearly how that would apply to independence is something that would arise much later on. But it's not that the IEC itself has criteria. The legislation says we must set a threshold for people who do not reach that threshold, who then forfeit their deposits. But if they go beyond that threshold, they get the deposit. It's just a question that we have to set the threshold, which obviously at this stage we haven't done because we don't have legislation on the basis of which to be informed. But Chair, I think that's the only question directed specifically to us. I think there are many others that for clarification, which we'll also be eager to listen to. Thank you.
Okay. Thank you, Commissioner Love, for that comment. I'm going to invite the advocate, the questions that have been, or comments that have been made, and then we'll invite Deputy Minister Nzunza, and we'll invite the Minister Mutsualedi. If there's any sort of legal team, we have to also invite them of Parliament, just to make comments there and there. Advocate?
Thank you so much, Chairperson. Perhaps I could just clarify, I will only deal with questions obviously relating to legal or constitutional questions. Any questions about policy considerations are not for me to deal with, they are for the department or the minister to deal with. But if I could deal with them, there are a number of legal or constitutional questions, and if I could go through my notes. The first question that arose, not in this particular order, but a question that arose was the use of the term regions. Let me start by explaining that when one speaks about a region in this context, one means a province. There would be 9 regions because, as Member van der Merwe indicated, the region is defined as having the same territorial area as a province. So there would be 9 regions. That is the way, in fact, the current Electoral Act works. It speaks about 9 regions. And the reason that it uses the term regions, and we've done the same, is to avoid confusion between regions or provinces electing people to the National Assembly on the one hand, and provincial legislature elections on the other. So that's the only reason we use the word region instead of province. And there are 9 regions, 9 provinces, just as is the state under the current Act. And in relation to the question that was posed, which is how do you determine how many seats are allocated to each region, that is determined in the bill by item 4 of Schedule 1A, which says that the Commission must determine a fixed number of seats reserved for each region for every election of the National Assembly, taking into account available scientifically based data in respect of voters and representations by interested parties. And that's precisely the same as the current provisions of Schedule 1A. It says that the Commission determines. So it's not that the Northern Cape gets the same as Gauteng or the same as KwaZulu-Natal. It will be determined on a population basis, effectively, by the Commission on the basis of the latest data available. Then if I could move to the next question, a number of questions arose in relation to the question of vacancies, where a seat becomes vacant. Let me start with the practical difficulty. From the practical difficulty, we don't understand how there is a practical solution to the vacancy. And let me just explain why again. Assume that the province of KwaZulu-Natal elects 3 independents, and at the end of the first year, one of them resigns. Then you run a new by-election, and 6 months later you elect someone. But a week after that, by fluke, the second one resigns or the second one passes away. Then you've got to run another by-election. Then the third one, and every time you've got to do it province-wide. In other words, the whole province would have to vote. And so we don't see that there is another practical alternative. And I note that although the Honourable Member Lakota has questioned that, his bill seems to adopt the same approach, as I understand it, in item 24.4, which says that a vacancy of an independent candidate will remain unfilled until the next election. So it might be unfortunate, but it is a consequence of the way this works practically. In relation to the question, Mr. Chair, that you and others posed about constituencies, I do appreciate the problem. But on my understanding, and you'll correct me if I'm wrong, constituencies are a practical arrangement arranged by the National Assembly. They are not a legal requirement. And let me explain why that matters. As I understand it, if a member of parliament, Ms. X, is given the constituency of Kimberley or the constituency of Southern Cape Town, that is simply a practical arrangement by Parliament, very importantly, to make sure that that constituency has a connection to a particular MP. But because it's just a practical arrangement, then what that means is that if there is an independent who dies or who resigns and the vacancy occurs, Parliament could deal with the matter practically by allocating 2 constituencies to one particular MP, or by allocating half of the vacant constituency to one neighbouring MP and half to another neighbouring MP. So because there is no legal requirement for constituencies, because it is simply a very important and salutary democratic practice, it can be dealt with at a practical level, and it doesn't need to be dealt with here, in my assessment. The third overarching issue that was raised was the question of discarding votes. And let me repeat, if I may, from a legal point of view, what the Minister said in December. It is correct that in any system, and let me emphasize, even in our system, votes are discarded. So if we think about the old first past the post system, where you've got a pure constituency and 5 candidates run, and one candidate receives 90% of the votes, well, 40% of those votes are effectively discarded, because he only needed 50% to be elected, and the 40% of the votes are unnecessary and are effectively discarded. Similarly, the 10% that went for the other candidates are discarded. So in a first past the post system, there is always the discarding of votes. Similarly, in our current local government system, votes are discarded in exactly the same way. If you vote for an independent candidate and the independent candidate gets in and got more votes than he or she needed, those votes are discarded. But lastly, even in our current National Assembly system, let's say that the threshold for votes in a given election is 40,000 votes per seat, and let's say that the ANC wins 100,000 votes. Well, their first 40,000 win them the first seat, their second 40,000 win them the second seat, and the other 20,000 are discarded. So I accept that the discarding of votes happens to a greater degree here, but it is only a question of degree. And that's because all systems involve the discarding of votes. And it does seem to me, strictly from a legal point of view, that the point made by Honourable Member Pillay is correct, and that's the way I've thought through it in understanding the constitutional implications. If a person makes an election to run as an independent, then they are held to that election. I'm choosing to run as an independent, and the most number of seats I can win is 1 seat, because that is the whole notion of an independent. If I want to form a political party, I must go and form a political party and call it the Stephen Budlander political party and have other people with me. But if I want to run as an independent, the maximum number of seats I can win is 1. And if someone wants to vote for me, if my junior Mitchell de Beer or Salome Mangani want to vote for me, they are voting for me knowing that the most number of seats I can win is 1. So if they vote for me and I win the seat, even if I had more votes than I need, it's hard to say that the will of the voters has been thwarted, because my choice was to run as an independent and I got my seat, and their choice was to vote for an independent to get me a seat, and I got that seat. And so their will has been respected rather than being violated. And so from my point of view, I don't see that there is a constitutional difficulty in that score. I can understand the argument, but I don't think that, it is correct. Then, Chair, if I could mop up a few other points. The question raised by the Honourable Member Groenewald about whether this is consistent with Section 46, and I agree, there does have to be a requirement of consistency with proportional representation, and this, in my view, does. Honourable Member Roos asked the question whether this had been assessed by the Parliamentary Legal Advisors for constitutional compliance, and the answer is yes. We had an extensive session with the Parliamentary Legal Advisors on that score. The Office of the Chief State Law Advisor on that score, I beg your pardon, the Office of the Chief State Law Advisor on that score, and that has been assessed. Honourable Roos raised the question about mistakes on the voters' roll, and is there a way of correcting it? That is not an issue that is addressed by this bill, because it doesn't arise from the question of independent candidates. And I don't want to comment on whether the bill, the previous act and the current practice is adequate or inadequate. It's simply not something that we've addressed, because it's a separate issue from the question of independent candidates. So if the Honourable Member thinks there's a problem, it's not one that's addressed by this bill, but it's also not a difficulty created by this bill. And then, if I could just check, Honourable Member Kanyile raised the question about what if a political party prevents the member from resigning. I don't understand in law how a political party could ever prevent a member from resigning, because political parties are voluntary organizations. They might be able to expel you, but they can't prevent you from resigning, because the right to freedom of association also includes the right to dissociation, and so one can always leave. I think Commissioner Love has addressed the question of the criteria for paying back. And then finally, Chair, you raised the question about the National Council of Provinces. There is no requirement for independence to be catered for in the National Council of Provinces. And you will see when you look at the Constitutional Court judgment, it speaks specifically about independence in the National Assembly and the Provincial Legislatures, and makes no reference to the National Council of Provinces. And in fact, when I looked at it, when you trace the provisions regarding the National Council of Provinces, how delegates are selected from the provincial legislatures, it's all done on a party basis. Now, that's not because of the Electoral Act. That's because of the Constitution itself. The Constitution itself specifies that it must be done on a party basis. And so there is no requirement or even any possibility, constitutionally speaking, of independence in the National Council of Provinces. They can be represented in the legislatures and in the National Assembly, but not in the National Council of Provinces. Thank you, Chair. I think I hope I've covered those, all of the questions.
Thank you very much, Advocate, for detailed responses on the issues raised by members and the comment. I will invite Deputy Minister Njabulo Nzunza to comment. DM.
Thank you very much, Honorable Chairperson, and I would like to follow suit with other colleagues and greet everyone and welcome them to the new year. It's our first portfolio committee for the year, and I hope that we are going to work very hard and very well together towards making sure that we meet our objectives as well as our obligations. Well, I think the first issue is that we can all agree as a portfolio committee that quite good progress has been made with reference to this bill and with reference to the Constitutional Court judgment, which is what brought us to where we are today. And on the issue of extension of timelines, which is the first comment I would like to handle, is that we have, as a portfolio committee, always agreed that we have to show commitment, that we are not going to sit back and then go and apply for extensions. We will do our work to the best of our ability, to the best of how we can be stretched. Only then, when we see that we are really not going to be able to make the timelines, we can then start applying, so that we are able to display to the courts that we did our best, but the timelines were short and it was sort of impossible. I think that kind of an attitude, like Honorable Malebo was saying, will really help us a lot. On the issue of discarding of votes for independence, as well as their issues of resignation, I don't think we will want to create a situation where you will have political parties that will masquerade as independents. Because if you start saying you can transfer a vote of an independent to another person, it means you are literally having a situation of a list of independents that will be submitted, and then they will contest as a group, and then as such there will be votes that are given to other people. I don't think that would work. If a person contests as an independent, they are an independent and the votes are for that particular independent. And I think if you look in terms of local government elections currently, when we calculate for proportional representation, what you call as PR votes, already the votes of independents that are gathered from the ward are subtracted from the entire formulation. So it is something that is already happening. And on the questions raised by Honorable Ross, I do not remember at any given moment in time that we will have skipped necessary processes in processing bills of Parliament. What we have always done is to make sure that we go for public participation, make sure that legal units are consulted. We even get certificates for these bills so that they are cleared and not to have been that they are consistent with the Constitution. So I think we will continue doing that. I don't think there will be anything that will be extraordinary there. It's a process that we've done with all of the other bills, so we'll stick to that. One issue that I suggest we must also do is to advise Parliament in terms of its management and the office of the Speaker, that this bill might bring some changes in how we manage the affairs of Parliament. Just a typical one, the issue of how we handle debates and the allocation of time, so that they can be able to start preparing their own systems to be in line with the bill, so that when it becomes an act, they will have already fine-tuned some of the issues. I would like to stop there for now. Thank you very much.
Thank you very much, Deputy Minister Njabulo. Minister Mtswalile.
Thank you very much. Thank you very much, Honorable Chairperson. And I think a lot of questions have been clarified by both Senior Counsel and the Deputy Minister. The question the comment from Mr. Groenewald is noted and appreciated, and I'm sure he will also agree that there's a lot still to do in the bill in order for it to be understood even by members of the public. Same as the issues of Honorable Malebo, who is asking about consequences of either option 1 or option 2. The consequence of option 2 is that if you look at it in totality, if we take option 2, we must immediately forget about any changes in 2024, because it's going to take a long time. Last night, one of the members of Ministerial Advisory Committee, Dr. Mpede, the political scientist at the University of Pretoria, I understand he was with a former leader of DA, Musi Maiman, debating this issue. And she gave an example that changing electoral system takes many years, and gave an example how in Australia, they started some discussion in 1982, and are only implementing it now about the electoral reform. So something to that effect. So these issues have consequences. The minimalist approach, the consequence is that we stand a better chance of meeting the Constitutional Court ruling. By the way, both of them, even if we started doing public hearings or whatever 24 months ago or 18 months ago, it will still have come to the same thing. Now, the question from Honorable Roos about whether the bill has been subject to constitutional scrutiny by Parliament, Advocate Bartlender has answered it, but I also want to add, on our side as Home Affairs, we don't deal with constitutionality from Parliament. We deal with it from the Office of Chief State Law Advisor, as I've already informed you. Any bill that comes to Parliament must come with a certificate from the Office of the Chief State Advisor, which said we have checked the constitutionality of this bill. It is not against the Constitution. And I've just told you that on the 7th of December, when we came to you, we did not have such a certificate, but we ultimately obtained it from the Office of the Chief State Law Advisor. And I'm happy to hear from Advocate Bartlender that they have also consulted the parliamentary legal system, and they too believe that it's not unconstitutional. Now, why was minimalist option taken? That's a question from Honorable Rios. I've partly answered it, but I also want to take Honorable Rios to the presentation that we made early last year by the Ministerial Advisory Committee. We emphasized that the Ministerial Advisory Committee, before going on to their job, they adopted 10 principles. And coincidentally, these are the same principles that were adopted by the Van Slabert Commission some 20 or so years ago when they were dealing with a similar issue. In fact, it's more than 20 years ago. When they were dealing with this electoral reform, they adopted 10 principles. The same 10 principles were adopted by the Ministerial Advisory Committee under Honorable Vary Musa. One of the principles is inclusiveness, which says South Africa's electoral system should yield a broad representation of South African population demographic, ethnic, racial, and religious diversity. This remains a significant value 27 years after apartheid. The demarcation of constituencies must not enforce apartheid special patterns. The second one is the issue of fairness, where there must be equal votes from every individual. Then the issue of simplicity, which Advocate Bartlender also spoke about in a way by referring to a ballot box, a ballot paper, to say, with hundreds and hundreds of names, which will eventually confuse the population. They will simply not participate and will throw lots of votes away. That's where a lot of votes will be thrown in. If a voter gets into a ballot booth and is given a whole book because there are 300 independents in there, that is not a simple system. Then accountability, which we all know what it means. Then the issue of gender equality. It says Section 9 of the Constitution enshrines the right to equality. The MEC should avoid selecting a system that will result in a reversal of gender equality. Dare I say, Chairperson, even though I know I'll be contested, it is but the truth that when you look at the local government elections, in the ward system, parties are unable to balance gender equality. Go to lots of political parties, you will find that a lot of women came through the proportional representation. They are not represented in the wards because it's not very easy. In this patriarchal society, where we are still fighting to change patriarchy, where a woman is elected as a ward councillor, there are women who are ward councillors and they've done very well. But all in all, if you look at the system, most of them are accommodated at the party list system because of the society which we have become, which we are still many years from actually changing. Then there's issue of proportionality in terms of Section 46 1D and Section 105 1D of the Constitution, proportionality in province and in National Assembly respectively. Then there's an issue of effective participation of independents. where we want independence, whether we pay a lip service or want their effective participation. That's why we are forced to consequentially change the Funding Act, because we want independence also to be funded. Then there's genuine choice. Is there a genuine choice on what the electorate is doing? Are they given a chance to choose between a political party and the person they want? And the issue of sending votes to somebody doesn't give genuine choice, because you are coming backdoor through somebody's voice. That's not what electorate will have chosen. Then the issue of effectiveness, then the issue of legitimacy. All these 10 conditions are the ones which informed us which system is more or less next to these 10 principles. And so we don't have reluctance to go to the constituency system is because of that. Now, the issue of region has been explained, and Chairperson, you know, you intimidate me when you are up here on the screen, and my papers get mixed. You are very intimidating.
No. I thought it's my right to.
Because of the power you hold.
No. Yes. Continue, Minister.
Yeah. No. Let me go to questions by Honorable Lukota. Honorable Lukota, I was listening to you attentively because I also want answers. I thought you'll provide them. On this issue of throwing an independent that passes on. In your own bill, Honorable Lukota, you are exactly that. There are two similarities between your bill and ours, which I'll come to. And one of the similarities is this issue, that you are agreeing with us that there is no mechanism of replacing an independent candidate who passes on or who retires or who resigns. But I don't think, colleagues, this is a disaster where you say the constituency will remain alone. Remember, in the Home Affairs Bill, this is a multi-member constituency. And I'm also answering Honorable Kanile that the constituency is going to be empty for 5 years. It can't be, because it was not like a ward system now where you are represented by one person. And that's why it's easy to go for by-election, because there was only one person and the ward is very small. Here is a multi-member constituency. Whether you take the Department of Home Affairs Bill, which say the whole region or province is a constituency, there will be lots and lots of people there. Even if you take the Lukota bill, he is talking about 52 constituencies, which amount to districts. They are still multi-member constituencies. So it's not like a ward, what we are talking about here. And I think that must be taken into consideration very seriously. There will be representatives, only that there won't be a representative chosen by one particular group of people, which we don't know yet because we can't identify, because it's a secret ballot. But there will be representatives, and senior council advocate Bartlett has tried to show how people can be catered. And I want Parliament to be innovative in that regard. Otherwise, you must just simply say, yes, we must run election on every single day, a whole provincial or a whole district election. That is a decision that this portfolio committee and Parliament ought to take. The issue of rejecting a candidate who resigns has already been answered, and the IEC has already answered their part. Honorable Van der Merwe, the issue of how we're going to work within 4 months, I think you must sit down as Parliament, as proposed by the Deputy Minister, to see what must happen to 2024. And I can assure you, we have tried our best, even in the choice of a system, to make sure that we meet 2024. The issue of region was clarified. Go to the previous presentation. No, go to the previous presentation that I've made. You realize that all these issues about the region, whether independents are given enough competition, are there. I want to finish, Chairperson, with the discarding of votes. But Honorable, Senior Council Bartlett and Honorable Deputy Minister have dealt with it. I'm not sure, Chairperson, I'm not sure at all why it is raising eyebrows now. We've been doing it from the year 2000. We've been discarding votes. and senior council have told you why, how. And I want to add, ever since local government came into being, we've been openly discarding votes of independence. Honorable Batlenta told you about the votes which we discuss of political parties in parliament, but I want to talk about independence. Since they came into being, once an independent wins a ward, their votes don't count when we count proportional representation to gauge who can actually win that particular municipality. In fact, if we were not discarding votes, perhaps some of the parties that are now in charge of municipalities might, in terms of proportional representation, will not have been. So I want to know, why is it illegal? Why is it legal, I mean to say, to discard votes of independent candidates in votes? And all of a sudden, when we use the same system presently, it is found to be illegal. I just want to understand that. Why is there double standard? Why is it raising eyebrows when we've been doing it from the year 2000? Thank you very much.
Thank you, Minister, for the responses.
Sorry, Chairperson.
I think you will assist us, the team of Parliament, as we move to the public consultation and deliberation on the matter. I'm going to invite the viewer to make comment from the public, from the legal Parliament. I see the advocate want to make a comment before we invite the viewer.
Sorry, Chairperson, just a point of order.
Yes, point of order is?
Chairperson, just on my one question, my question was not whether the bill has been assessed for constitutional, against constitutional muster, it's whether it has been assessed against the Constitutional Court judgment and whether it satisfies the requirements of the Constitutional Court judgment.
Okay. I think a viewer will clarify that when it deals with the issues that we raise, which are related to the parliamentary legal services. I'm going to invite the advocate to make comment. I see your hand, advocate. Recognize.
Thank you, and I apologize for interjecting, Chair. I misspoke. I said that I had discussed it with the Parliamentary Legal Services. That is not correct. I had discussed it with the Office of the Chief State Law Advisor, and I had discussed it with the Office of the Chief State Law Advisor, both with regard to constitutionality and with regard to the issue raised by Honourable Roos, which is, does it pass muster under the Constitutional Court judgment? So that addresses his last question. But if I was understood as saying that I discussed it with the Parliamentary Legal Services, who I know well and respect greatly, that was not the accurate impression, and I apologize if I misspoke.
Noted. Thank you very much, Advocate.
Thank you.
Viewer.
Thank you very much, Chairperson, and good morning to the members.
Viewer, can you a bit, you're not properly audible. If you can increase your...
Okay, yes. Let me try again, Chairperson. Is it better now?
Yeah, it's better now. It's better now. If members who don't hear him, you will indicate so that we advise him. But I think you can proceed.
Good morning, Chairperson, and to the honorable members and colleagues that are on the platform. Chairperson, there are just 2 points we would like to comment on at this moment. There is a lot that has been said, which we consider to be policy considerations, and we will be very reluctant at this stage to enter that space, because that's for the committee to consider. But we would like to speak on 2 issues, one being the issue of the constitutionality that has been raised. And again, we will enter that rather cautiously, because there is still a public participation process that has to be followed by Parliament. So we wouldn't want to make any definitive determinations in that before that public participation process has been concluded. But in our assessment of the bill as introduced, and in the advice that we have given to the joint tagging mechanism, our conclusion was that there is nothing manifestly unconstitutional about the bill as introduced. But of course, we are very mindful, Chairperson, of the nature of public participation. People are going to come back to Parliament, make suggestions, make criticisms, And these are the criticisms that we need to consider as Parliament with an open mind. And if there is any suggestion at any particular point that there may be areas of unconstitutionality, and they have to be considered at that time, and we will give advice on that particular issue. There is a second issue, Chair, like I said, which is the issue of the public participation itself. And I will limit myself really to the issue of the committee making the assessment. Between now and the 10th of June, you have just under 5 months. It is for the committee to make an assessment and determine that if we have to engage in public participation, and maybe I need to qualify that, meaningful public participation, is that sufficient time for the committee, both this committee and the NCOP to be able to deal with the bill and pass it and comply with the standard of meaningful public participation. And our advice as the legal services will be, if there has to be any application for extension, it has to be done at the earliest possible time. And this may be the time if the committee is satisfied right now that it will not have enough time and the NCOP will not have time. So this may be the right time so that we are not seen to be lax in how we are approaching the Constitutional Court. In the previous judgments where we had approached the Constitutional Court, the issue was always that an extension is not there for the taking. It must be motivated, it must be substantiated. And the sooner you realize the danger of you not complying with the court order, the better for you to approach the court in good time, because that helps to demonstrate your bona fides in terms of your application. As to how the court will deal with the issue once it has that application is a different matter. But that will be our advice, that the sooner the better. Once the committee has made an assessment that it's impossible, it should be done quicker. Thank you very much, Chair. At this moment, we will limit us to those 2 points.
Thank you very much, Siviwe, for your comment and advice, which the committee will deliberate and take it forward. I must thank the Minister and Advocate on this item, that they've worked hard to make sure that finally the committee begins with the process of interacting with this presentation, this bill. We'll know or recall, members, that there are 2 areas were contributed to the delays of this bill. One, the past 2 years we have been affected by the COVID-19, as all of us know, and we're passive to interface with the bill. And secondly, we're confronted with the local government elections, which also contributed to the processing of the bill. But given also this environment, the advocate and the minister has worked so hard so that we attempt or we meet the Constitutional Court judgment time period. In this case, that we are recommitting ourselves that Parliament must be responsible to ensure that we comply with the Constitutional Court judgment. We allow residents, those independent, to participate in both provincial and national assembly. It is with this background that Siviwe, your last comment, will able to guide the committee as we make a clear assessment on how we must respond or give notice to request an extension, because we will need a broader consultation with stakeholders and our people that must guide the finality to this bill. And that is a commitment the committee will carry, that public participation must able to sort to ground a submission from members' consultation, and correctly saying that they're going to critique the bill and must allow that space to continue, that at finality when the committee conclude this process, we're able to give a fair process to Parliament and for the Parliament to consider in line with the Constitutional Court judgment. We will interact with the Parliamentary Legal Service post this committee, and once we've deliberated on the issue next week, to advise the committee, the legal service, to consider, given the program of action that we'll be designing, which will request Mr. Matonsi to develop a program of action in terms of the public consultation. And you are carefully raising that meaningful public participation that will ensure that our people and stakeholders participate on this process. We'll then allow the item to be closed as such. We'll interact in the next meeting. We'll request Mr. Matonsi and the legal team, once we've interacted with them, to present a program of the public participation. You'll know that we've already issued an invitation for comments for submission, as has been highlighted to the meeting. Members are agreeing that it will be important that we extend public participation. We are guided by our people in terms of the options that have been presented here. The cabinet have taken a view that option one is the most workable one to respond to the Constitutional Court judgment, but will in essence await the public comments, deliberation from the committee, and at that particular time, once we're able to have guidance, we'll then able to present to Parliament on the options that we must take. At this level, we'll receive both options as the minister has presented, subject them to the consultation process and engagement to our people. I want to thank honorable members on this item particularly, that it will need our collective strength and focus to make sure that we comply and satisfy the Constitution of the Republic in terms of the process we're going to enter into. Minister Arun Zwaled, I'm going to invite you to make comment on the on the Veteran Lokota private members bill as been requested, just to also highlight, because this process we've just stand off. It has at least empowered members of the Parliament, of the committee, and those that are participating to understand the process that has been unfolded. And I think it will be important that also you comment on the bill, private members bill, that Minister Veteran Lokota has presented to the committee. I don't know why I'm calling always calling him Minister Veteran Lokota. Minister Mzoledi.
Thank you, Honorable Chavan. You're not far off. He was a minister at some stage for a long time. So it's not far-fetched. Chairperson, I am presenting the comparison between our bill and the bill offered by Veteran Lokota, and I'm happy that he's present within the space where I go wrong. Obviously, he'll correct me, but I'm presenting this from our point of view, from the way we understand what he has presented. You still, as a committee, have to scrutinize it, where you'll come and explain for himself. But from our point of view, as you can see on the screen, the first thing is that in the Home Affairs Bill, we are simply doing what the Constitutional Court has said to accommodate independence, with very little changes to the acts. But if you look at the bill presented by Honorable Lokota, it does not only amend the Electoral Act 73-19, Electoral Act number 73 of 1998, as instructed by the Constitutional Court, it will also want to amend the Electoral Commissions Act 1996. The Electoral Commissions Act 1996 is the founding act of the IEC. In other words, the bill as presented by Honorable Lokota will change the law under which IEC was established and change the structure of the IEC itself. That is the first thing. Now, the Constitutional Court judgment, the New Nation Movement, versus president and others, was based on Section 18 and Section 19 of the Constitution, if you remember. But we are actually dealing with that. But if you look at the bill from Honorable Quota, it attempts to change the whole electoral system from a closed list proportional representation to an open list. If I'm not mistaken, if I have to explain, unpack what it actually means. A closed list party system is the one we are using today from political parties. An open list is where political parties comes with name, but during election, members of the public have got the right to reorder the names. If on the proportional, on the closed list of a political party, Aaron Mutwale is number 1, the voters can go and make him number 100 in terms of their votes. That's what is meant by an open list, where voters have got a choice by choosing between members of a particular political party who they prefer over the other, even if the political party has put their pecking order. So, so the bill is more about general electoral reform as far as we are concerned. Point number 13, that the Home Affairs Bill targets the constitutional problem raised in the new nation movements. And it does so. We are just being precise and say, the court says, please change this, and we are doing so to accommodate independent candidates. If you move to point number 2, that the central difference has a significant implication, which is what a question asked by Honorable Molekwa. The bill presented by Honorable Quota will require the Commission to split the country into 52 constituencies, if not more, but the 52 corresponds more or less with the district. At least that's what they are proposing. Now, this is the task that the Commission is not presently doing. The IEC is not doing that. The Municipal Demarcation Board is only empowered or authorized by law to demarcate municipalities for local government elections. So if we must divide the country into constituencies, and we believe that's why the Honorable Lukota's bill wants to change the IEC as it is and change the founding act of the IEC, because we have got to find the structure that must do those demarcation. Point number 2.2, under the Honorable Lukota bill for the National Assembly, 6/7 of the seats will be filled by names submitted by political party lists and independent candidates. The remaining 1/7 of will be filled from political party lists. The Department of Home Affairs bill uses the 3-round allocation system. As you remember, I presented. Chairperson, was I stopped or what?
No, I think there's other members. Can we mute our? Sorry, Minister, for that disturbance. Can you proceed?
Yeah, no, thank you. So where you are aware that on the 7th of December, we presented that seats will be allocated in 2 tranches. But here, this is not the case. On point 2.3, the Honorable Lukota bill does not contain 3-round system of allocation because on item 15 of Schedule 1A of the bill presented, it is contemplating allowing independent candidates to award their surplus HH bill, as we've already said, is that like is the practice now, like is the practice internationally. Once an independent candidate reaches a threshold, there is no more, their votes are no longer of any use, and that's why they get discarded. On section 2.4, the Department of Home Affairs does not require independent candidates to register with the Commission before they are nominated. But the Honorable Lukota bill, in contrast, in section 15A, will require independent candidates to register with the Commission and then be nominated before the election. We believe this creates an extra hurdle which an independent candidate will have to go over, and we believe it may undermine their good intention, because their bill obviously has got good intention on independent candidate. But unfortunately, we believe this particular requirement that they must register with the IEC first. We'll do that, but it will also add a large administrative burden to the IEC itself. Now, the similarities. There are two similarities between the Department of Home Affairs bill. They are on item number 3. Item number 3 are the similarities. There are only two. Similarity number 1 is that the Honorable Quota bill proposed that we return the current group formula for determining the quota of votes per seat, which is the same as the Department of Health bill. That's what exactly we are saying in the Department of Health bill. We are saying there must be a Droop formula. You remember the Droop formula is the formula you apply to political parties. After you have the same as us in that regard. Then the second thing on the Quota bill, item 24 subsection 4 of the Quota bill has the same approach as the Department of Home Affairs bill, that the vacancy of an independent candidate will remain unfilled until the next election. I'm not sure why today he has asked this question, because it's on his bill. Maybe he might be here to explain exactly what it meant, but we interpreted it to be meaning the listing chair. Even if we went to the second option, I'm sure it will still be they are still talking about the multi-party constituency. Even in the Quota bill, it's a multi-party constituency because it's a district. So the main difference between his bill and the Home Affairs bill is Home Affairs, the constituency is the province, they said it's a district, but none of the bills are talking about small constituency like the wards. There's no bill at the present moment put in front of Parliament that says that. Now, our small criticism, or let me not say criticism, but rather critique of the Quota bill is that, firstly, the bill proposed wide-ranging substantive amendment to the electoral system, as well as the Electoral Commission Act. And we believe that is a lot of work. And if we do that, let's forget about 2024. The current legislative process is to ensure that we comply with the new nation movement judgment, the Constitutional Court judgment. And we've got a deadline that has been imposed. If we want to meet that deadline, going to change starting from changing the IEC structure itself, let's understand and accept that it will take a long time. We believe the Constitutional Court may grant that extension, not to finalize the act by June, but we don't think they will give us an extension that we must go through 2024 elections without any independence. I'm not sure whether that will be allowed, but if we are looking at the Quota bill, it's going to lead us to that by 2024, there's no way we'll have finished what we want to do. We believe it's not impossible, but it's extremely difficult. I can't say it's impossible, but I'll say it's extremely difficult. Let's move to point number 6. Yeah, this is the issue of transferring surplus votes as an award. It has been debated thoroughly today. We've given our reasons. We believe this is a backdoor way of coming through to a political party by donating your votes to somebody else because you happen to be having common views. Then if you have got common views, why don't you just form a political party right away, because the rules allow? And if you donate your votes to a particular political party which already exists, why avoid joining it, but you think they are good enough to have the votes from your voters? And lastly, why would the voters agree that they vote for you and your party are given to somebody else who they chose not to vote for? So those are the problems that we are having. Thirdly, on number 7, section 15B of the Quota bill will impose additional obligations on independent candidates in respect of registration. I think I've already mentioned that. Maybe, and we also believe section 15A on if you move to 7.1. Yes, we also believe the section implies that the candidate, the independent candidate will have to renew their registration every year, also exacerbating the problems of the IEC. Chairperson, I think let me stop there. Thank you.
Thank you very much, Minister, for the critique to the observation on the weaknesses that are arising from the private members bill presented by Honorable Quota. And I think I would advise that you delete that heading, criticizing, as you are really affirming that you are attempting to critique or to make observations on key areas that we thank you for making that the deliberations.
Agreed.
Yes, yes. I'm going to invite Honorable Lokota if there's a comment, because we're going to subject these deliberations by the committee in the next committee meeting, so that we are able to take through how both the advocate, the minister, and this critique. Members have gone through the bills, these two bills that are presented to the committee, and also we did receive a presentation to that effect from Honorable Lokota in the executive bill that has been presented and tabled in Parliament on the 10th of January 2022. We are going to invite if Honorable Lokota want to make a comment. If he doesn't want to make a comment, we'll make contributions in our next committee meeting when the committee is going to deliberate on the issues as we move forward.
Thank you, Comrade Chairperson. Can you hear me, Chairperson? Hello?
I believe the Chairperson is having connection difficulties, Honorable Lokota.
The Chairperson is what?
Connection difficulties.
We can hear you.
Oh, you can hear me, thank you. No, I just wanted to say that I'm very grateful for the feedback that the Minister has just presented to all of us. And so I will reserve my response at this present time. I'd like to report back to our party, and then in the next meeting, if there's anything, I will then indicate, and then I can put forward. But at the present time, I have nothing to say back to the Minister. Thank you. Can you hear me?
Yes, we can.
Yes.
Honorable Lokota, we can hear you very well.
Oh, thanks. Yeah. You heard everything I should say.
Yes, no, we heard everything you have said, and I agree with you wholeheartedly. That's why I agreed to withdraw the word criticism and said it's a review of what you have said, and I want a live debate on that one.
Oh, thanks. Yeah.
Thank you.
So apology, we're load shedding here, so we've been disrupted. I'm not sure whether Honorable Melve, whether Mr. Lokota, Honorable Lokota did take a platform or not. Can I establish that?
Yes, Chairperson. Honorable Lokota has responded to the Minister, and he said he would reserve judgment and get back to us.
Okay.
Thank you, Chair.
Thanks very much, Honorable for an apology, members. It's beyond our control, the load shedding. We're going to end up the two items as such. We've made a summary in our first item presented by Advocate and the Minister, and we've received a comment from former First Minister on the issues arising from the Honorable Lokota's bill, and we're going to interact with this process in our next meeting. Can I establish, Mr. Matonsi, if there's an announcement?
Chairperson, no, there's no announcement, Chairperson.
Okay. There's no announcement, members. Want to thank you. Thanks, Minister. Thanks, Advocate. Thanks, honorable members and Honorable Melda for joining the committee meeting. And thanks, Commissioner Love, with your team, the entire staff component of Parliament, the legal team, and the team that have been brought by the Minister, we want to take this opportunity that this hard work we have demonstrated at a difficult space for the past year, with the intention to comply to the Constitutional Court judgment. We'll make sure that we recommit ourselves as a collective, that we indeed get to the ground, interact with our people, so that ultimately we have a decision on this process of the bill. I want to take this opportunity to thank you, and the meeting stand adjourned.
Chairperson, sorry, just before we go, just to indicate there was one more item left on the agenda, which was the discussion of the motion of desirability on Honourable Lekota's bill. But we've, as we discussed before, we will allow more time for consultation so we can discuss this in the following meeting, along with questions of extension and possible provincial public consultations. Thank you. Thank you, Chair.
I think what we discussed, Honourable Adams, around that point, you are part of the meeting with the chair and the secretary of the committee, and I'm not sure how are you attempting to advise the meeting to do, because there's a decision on that matter, and we're advising yourselves and the team that we're going to deliberate on the issues in our next meeting.
Noted, Chair.
Thanks, members. The meeting is ended.
Thank you, colleagues. Bye.
Thank you very much, Chair. Thank you, Honourable
Thank you,
members.
colleagues. Bye. Bye, Chairperson. Bye.
Bye.